We are releasing as much as legally allowed. That's why we went back.
How is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders
Actually,
work? You know,
Mr. Patel, I was a real prosecutor for 10 years. I know exactly how.
So I was a fake one?
During a tense exchange, a former prosecutor pressed a government official with one crucial question that tore through the legal barriers supposedly shielding the Epstein files. The official's answer came back carefully crafted. It wasn't meaningless rambling, obviously. Rather, it was a textbook display of how to weaponize legal terminology for one specific purpose, obscuring what citizens have been asking for repeatedly, straightforward facts. Yet consider what the official deliberately left unsaid. That's precisely where the actual narrative unfolds. This isn't simply about another frustrating government hearing that leads nowhere. This is fundamentally about deciding whether we're genuinely safeguarding the people who are actually harmed or whether we're defending an apparatus deliberately designed to keep names permanently sealed away. Give a suggestion and comment below.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders that prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
And you're talking, and I said that's 6E, and I said there was others, and I'm answering that there are sealed court order documents. There are protective orders.
They are unsealed as part of discovery given to Ghislaine Maxwell. They are no longer sealed.
That's just not true. We can argue about it all you want.
Okay, well, you agree that there are, so your testimony here is that the reason why you are not releasing all of the videos that you have acknowledged, there are so many, and that the FBI spent thousands of hours of reviewing, the photographs, and the photographs that you have. You're saying that you're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is pornographic material that was downloaded from the internet and child sexual abuse material. We will never release that.
Well, as you should not release the victims, but if there are videos that relate to others who Epstein trafficked to, such as maybe Prince Andrew, or photographs, that you have total control to release.
Yes, and if it exists.
And so why haven't you released it?
Why are you supposing that that is a fact when in fact it is false? Are you saying that
you're saying that none of the videos relate to anything relevant to the Jeffrey Epstein trafficking ring?
Every single video that we have collected pursuant to the prior search warrants has been examined for the last 10 years. And every single video has been utilized for whatever prosecutions were able to be legally brought.
I'm not asking about prosecutions. I'm asking about why you aren't releasing the full Epstein files, including the names of people who were involved in the ring that you promised to do before you became FBI director.
I just told you I'm not going to release downloaded.
I'm not asking about that. Fine. I'm asking about all the other files.
What other videos? Tell me. Tell me.
That's what I'm asking.
Tell me.
You're saying there are no videos that would be relevant to anyone else involved in the Jeffrey Epstein sex ring.
Pursuant to Mr. Acosta's collection of information based on the search warrants. That's all we have in our possession.
And I'm asking you, that stuff.
That's all we got.
I'm not asking all you got. I'm asking you, in that stuff, there's nothing that's related to any other people engaged with Epstein in underage sex.
That's correct. To my knowledge, no.
Okay. Let's talk about the witness interviews. 302s of witness interviews. Those are not subject to the court order. Those are not subject to any fictional sealed order for a search warrant. Why aren't you releasing those with the redacted names of the victims?
We are releasing as much as legally allowed. That's why we went back to the
How is
courts.
how is that not legally allowed?
Sir, do you know how court orders work? Do you know how protective orders
Actually,
work? Do you know how
Mr.
sealing
Patel,
orders
I was a
work?
prosecutor, a real prosecutor for 10 years. I know exactly how.
So I was a
court
fake one?
orders. And I want to understand what the court order prevents you from releasing witness statements that the FBI took.
You should know that as a real prosecutor, when the court hand downs a protective order and a motion to seal, the material is sealed unless that
Your
judge
testimony
waives
here
it.
is that all of those witness statements are under a court order, a protective order.
We are providing everything we can legally provide.
No, that's not my
Congress has
question.
sent us a
My
subpoena.
question is, why are those witness statements that are not grand jury testimony, that if they were under a protective order are no longer under a protective order, why are they not being released?
How are they not
And
under a protective
Why
order?
are you not going to the court like you did for the grand jury testimony to unseal those
The
records?
DOJ did go to the court.
No, not on those records. Why
Time
aren't
of
you
the
going?
gentleman.
You just went on grand jury.
Time of the gentleman has expired.
You are hiding the Epstein files,
Time
Mr.
of the
Patel.
gentleman has expired.
Step back for a moment and see what's happening in real time. This isn't theoretical debate. We're watching an actual former prosecutor named Goldman take the stand against a career government administrator named Patel over documents that rank among the most sensitive in modern American history. Picture someone trying to extinguish a raging fire using a cup of water while standing directly next to an open fire hydrant. That's the dynamic here. To really understand why this conversation carries so much weight, you need to zoom out. The narrative we've been fed consistently for years remains unchanged. We like nothing more than to open these files, but legislation prevents us. It's the perfect deflection. Goldman dismantles this convenient excuse by zeroing in on one critical element: actual human identities, not vague references to dollar amounts or classified designations. He demonstrates a progression from initial commitments to transparency to what exists now, an impenetrable fortress of sealed legal documents. Goldman isn't interested in theatrical posturing. He relies on his background as an actual prosecutor to systematically examine each component of Patel's argument. The official leans on Rule 6E, the statute protecting information gathered during grand jury proceedings, claiming it's the fundamental reason these records remain inaccessible. But observe how Goldman's analysis reveals the flaws. He points out that 6E doesn't function as a blanket prohibition. It doesn't apply to search warrant applications. It doesn't apply to materials that surface publicly through the Maxwell proceedings. Suddenly, that supposedly impenetrable barrier looks far less formidable. Patel insists that extensive video documentation is far too delicate for public disclosure. Yet Goldman isn't pushing for unrestricted access to everything. Instead, he's pursuing specific items. Server activity records, those witness statement documents filed by the FBI, the 302s, plus the actual identities of connected individuals. Pay attention to what shifts when Goldman focuses on those 302s, which represent genuine testimony gathered by investigators. These documents aren't bound by identical secrecy restrictions. Suddenly, the conversation becomes uncertain. Suddenly, Patel brings up protective agreements that Goldman contends don't currently apply or never apply to those particular documents in the first place. It's the pivotal instant. Whenever inconvenient information emerges, the response becomes a complex maze of legal exceptions. Patel maintains that all legally permissible content is being disclosed, yet stumbles when asked to clarify why the Justice Department has employed the identical unsealing mechanism for additional records that they utilize with grand jury statements. The contradiction becomes glaring when you examine the numbers. When federal investigators allocated that volume of hours examining sensitive photos and recordings, particularly materials implicating prominent figures, including Prince Andrew, what justifies bundling them with irrelevant documents as rationale for comprehensive suppression? Goldman isn't operating in an abstract space. He's challenging whether the justification holds any actual weight. As the allotted time runs out, Goldman articulates his parting observation: these files remain concealed and accountability belongs somewhere. Patel's reply is straightforward rejection, although his evasion regarding the 302 documents and the mechanism for unsealing leaves the core issue hanging without resolution. Access versus institutional interests. This represents the essential question being posed. We have the option of demanding that these witness accounts be formally declassified and made public, or we accept a situation where authority figures continue employing legal terminology as a mechanism to restrict information. Goldman made evident: harmed individuals are seeking an outlet to communicate their experiences, yet they're receiving silence in response. Make public the 302 documents, lift the restrictions on sealed materials, reveal the identities involved, or at minimum, come clean about what's actually creating these impediments. The underlying question persists. Do these legal barriers constitute legitimate obstacles, or are officials construing them in the most restrictive possible interpretation? Shouldn't these investigator-compiled witness documents become public immediately,